right. Well, I will let you lead this whatever way you want. If you want to just talk about, the fact that I think, which is news to some people, that, how settlements are taxed and how the payout is made will affect how it's taxed. If you can just start there, what should somebody's looking at a settlement agreement? The employer said, we will pay you, just pulling a number out of a hat, $30,000 to resolve this dispute. How do you want us to pay this out? How should they be thinking about this?
Yeah, I like the hypo. And to your question, some forms of damages are taxable, some aren't. Sometimes attorneys' fees can be deducted and not. And having a good attorney to negotiate the settlement agreement that takes into account tax issues is really important, because the Internal Revenue Service will generally respect the decisions made by the parties. And generally speaking, the defendant, the company or whoever it is, they're getting to deduct the legal or the cost of the settlement on their end, and they generally don't care. The incentives are the same for them. I mean, maybe they want a concession by having you save your taxes, but for the most part, it's negotiable. But to your question, Tom, out of the 30,000, it depends on what it is. Is it for lost wages? Is it for pain and suffering? Does it relate to a personal injury, a physical injury or sickness? And the rules are kind of gray there. We can talk about it. Is it reimbursement of expenses? That in most cases is not taxable. So it really depends on what it is. And obviously you want to allocate as much as possible to non-tax items. I mean, we all want to pay as little as tax as possible. We don't want to get in trouble with our friends at the IRS, but as far up to the line as you can go, that's generally what you want to do.
Yeah, no, I think that's good advice. Let me ask you, so it's the general rule of thumb that we've always operated on and most defendants are comfortable with, because sometimes, if it's a lump sum payment, let's say $30,000, unless that's arguably all lost wages, then it's a kind of a little bit of a gray area, like, how much we split, how we split it up. And in non-contingency fee cases where somebody has already paid attorney's fees to us, then it's just a matter of like, how's that money going to be distributed? Normally they'll write the check to us, and then we feed it back to the client and to reimburse them for the attorney's fees, which of course is perfectly appropriate. But the general rule is kind of a third, a third, a third. Is that just something that we've made up in the employment law realm, or is that sort of, what I've heard from defense counsel as well, the IRS is not going to take, going to look askance of us if we do it that way. If we do it differently, if we do it, so more of it is a 1099 and less of it is W-2, like say 10% W-2 and the rest is 1099, then we might get in trouble. Is that right?
Yeah, so just to make sure I understand, a third is attorney's fees, a third is like emotional distress on a 1099, and then a third is like W-2, lost wages, withholding. Right. And just so we're all on the same page, obviously you want as little as possible to wages and as much as possible to the two other items, right? Because if it's on the emotional distress damages that are on a 1099, you don't pay any self-employment tax on that. You don't pay FICA, you don't pay Social Security or Medicare. If you look at your pay stub, you see federal income tax withholding, probably Virginia or whatever state you're in, tax withholding, and then Medicare, Social Security, which is like 7.6%. You don't pay that on the emotional distress. So there is no hard and fast rule there. I think so the government's view, it depends on the facts and circumstances. So I think you could always argue. I would agree that allocation they probably wouldn't overturn because it's very reasonable. But I mean, if it was 1090 and you could justify it, I would say go for it.
Okay.
For the most part, the rule is that the government will respect the negotiated allocations of the party in the settlement agreement. Situations they don't, they're looking at what was the interest of the payor, were the parties adverse, and specifically as to like the allocation of the claim, and what was alleged in the complaint, if there was one, like what were the claims made.
Yes.
And so in most cases, those issues allow for aggressive allocations unless it just doesn't make sense, right? And
Yeah.
like I said, it's facts and circumstances, but to your general rule, I think I would feel very comfortable defending that, and I would say maybe try to go
A little more aggressive than that.
yeah, why not?
Yeah. Yeah. And then, and if you could talk just a little bit more for those of us who are math challenged. So, I mean, well, kind of what the tax savings would be. So let's say, we're going to try to be more aggressive. We're going to do, let's say, a $30,000 hypo. We're going to do 5,000 to lost wages. We're going to do, 15,000 for 1099 pain and suffering, and the 10% to attorney's fees. How much tax savings are we talking about here?
So I'm also math challenged. I bring a calculator into every client meeting, so that's why I'm pulling open my phone. So give me those numbers one more time.
So a $30,000 settlement, 5,000 is W-2, 15,000 is 1099, 10,000 is reimbursement for attorney's fees.
Okay. So the attorney's fees, let's start there before I give you to answer your specific question. So technically those attorney's fees are income to the recipient. Practically speaking, and please tell me if this has been your experience, Tom, the defendant or the payor doesn't always 1099 the plaintiff for the full amount.
That's right.
1099, they issue a form 1099 to them for the 66% yes. or whatever the take out the attorney's fees, whatever yes. was left. Remember, right. I'm math challenged too. So,
we'll go. We know what you mean.
Yeah, and so then they 1099 the law firm, presumably they were paid directly, right? That's actually not how the government looks at it. They actually, the 100% of the entire thing is income to the taxpayer. In employment law, it doesn't really matter though, because you can deduct the legal fees dollar for dollar. So, it's not a big deal.
Yeah.
In other areas, it is a big deal. And I know many people that will take the position and only report what's on the 1099. So obviously that practice is a good thing for taxpayers, but just to put on my government hat, that is not how they view it. Okay. But to answer your question, so, you got 15,000 of pain and suffering that you do not
yes.
pay FICA on. And I did not look this up before, so I'm going off the top of my head. I believe that the employee pays 7.65% of Medicare, Social Security, FICA taxes. So I'm going to take 7.65% of that. So it's like a little over $1,100 in FICA taxes that are not paid on the 15 grand. So, and I guess if it was, I guess the real way to calculate this is if you did it a third, it would have been what, 10,000?
Yeah, 10,000.
You're talking a $5,000 difference, really?
Yeah, yeah.
5,000 times 7 point, so you're talking like $400,
Yeah.
So for a smaller amount, not so much, but if this was like 100,000, 200,000,
yeah.
300,000, you're talking real money.
Yeah, yeah, no, but I think it's a good point. I do want to get back to the attorney's fees too, because, when we're going through these negotiations on the employment side, obviously for the reasons you just outlined, we want to try to the extent we can, minimize the W-2. Sometimes employers just won't, I don't know why, they're just like, no, like we want to pay it out all in W-2 and that's the only way we're going to do it. And there's nothing we can do to force them other than to reject the settlement, which often isn't an option. there's nothing we can do to force them to take it a different way. And I think it's important for people to remember, of course, if you're talking about big dollars, and it might be some like, I mean, like six-figure kind of dollars, it's something worth fighting over. If it's $30,000, like it's 400, you would have gotten a $400 tax savings had they done what we wanted to do, like, sometimes I think it's useful to hear it from you, because we have to explain to our clients like, hey, look, yeah, like all things equal, we would have preferred more of this under 1099,
Sure.
but we're talking about a less than $1,000 difference in money in your pocket. So is that something really worth blowing this whole thing up for? Because it's true with all settlements. A lot of times it becomes so emotional. It's like, well, screw them. They're not going to do what I want to do. They're not going to pay it out. And it is sort of frustrating because there's no good reason for it. But sometimes they're just like, sorry, we're just not going to do it.
Yeah, the SOP for the accounting department says they have to do it like this.
Right. Right.
Someone, I hear you, and I've had a lot of cases where after the fact, like everything's settled, it's a year later, a 1099 gets issued, and the settlement agreement is not clear on what should have happened. And I'm tasked with calling the accounting department or in-house tax counsel or whatever and explaining to them why what they did is legally inaccurate. And that is a tough decision. That is a tough case to make, and because they don't care anymore. And
Yeah.
I mean, same thing though. On the front end, if they're dug in, to your point, some battles aren't worth fighting. $400 probably not worth it. But
yeah, right. Because I mean, that's right. I mean, there's nothing right. I mean, I guess one can make the argument that it's not legally correct the way they want to pay it out. I'm trying to think what leverage on the plaintiff side we would have to, to leverage them to help them see the light. Is there anything, or is it?
I mean, other than the fact that you're willing to settle and it doesn't change the bottom. I mean, look, so the employer has to pay half of FICA. So like,
right.
So,
it benefits them to do.
Yeah,
10.
they should care. I mean, I'm sure they're risk adverse and they're worried about getting audited. And they heard somewhere it's a third, and they think that's some magical rule that the IRS cares about, even though it doesn't exist. But yeah, so financially, it benefits them to do it too. And, like I said, on the total dollar amount, they have a deduction if it's 1099 or W-2. It's just the tax liability that both sides have to pay goes down. So yeah, I mean, I rarely get involved at the settlement level. I'm usually like after the fact, but the few that I've been involved in, it seems that, like all things, some people are more reasonable than others, right? Some third parties are, and some are willing to work with you because they want to get it done and they see that it doesn't matter to them that much. Others, for whatever reason, they're difficult.
Yeah. Yeah, no, I think that's, and in most cases they are, they're willing to work with. Just every now and then we'll get one. They're like, nope, we're only doing it W-2. We did have one go the other way, and we're like, nope, we're paying out all 1099, no matter what. We're like, okay,
Probably had tax counsel that was telling them to save 7.65%.
Yeah, right. But let me ask you and again, that's very rare for an employer to do that. But what is the like? Because arguably some of that should be W-2, right? I mean, the IRS could say, look, you guys, you're just trying to escape tax liability. I'm looking at your complaint here, and one of the items of damages that you have got here are lost wages, and you're showing me a settlement that's all 1099. What are the risks? Because we had to talk to our client. We're like, hey, we think the risk is low. You might talk to your CPA, your tax person. Arguably, some of this should be W-2. IRS, if they wanted to, could take a different position. The chances that they are can be pretty slim. But what are your thoughts on that?
Yeah, I mean, I would fall in the camp of some lost wages, even if it's minuscule, better than nothing.
Yeah.
But I would need sort of some facts, but I think you would try to come up with. Let me back up. First of all, you have to get audited. Circular 230, which is the rules of ethics for tax practitioners, prevents me from telling anyone or providing any advice related to audit risk or audit rates or rules or anything of that nature. So this is not advice. I'm just stating facts and reality that like 1% of taxpayers get audited. Okay.
Right.
So you have to get audited first. Then they have to overcome the burden that is the settlement agreement, right? So the terms of the parties are supposed to be respected. They would have to come in and say that claim involved lost wages for whatever reason, right? And I, to your point, I think in most of these that it's an employment situation. They were being paid a salary, so
right.
You know, so it would, you know, maybe the facts are such that what happened to the person was like horrific, right? And that's why the emotional distress, pain and suffering, damages, whatever it's categorized as, is so high. You know, but like I said earlier, I would fall in the camp of even if it was like $1,000, $100, something that's better than nothing.
Yeah.
But you know, if you could also say, you know, hey, that's what that side wanted to do, and you know, we tried to get them to change their position, and they wouldn't, and you know, and the likelihood of the government auditing it and changing it very low.
Yeah, yeah, they're not. I imagine they're not around sniffing around for $30,000 settlements.
They don't care about that one. Now look, like sexual harassment cases, I do think there will be some scrutiny there, because in the Trump tax reform that was passed and effective in 2018, that a provision was included where you can't deduct, the employer cannot deduct fees paid for a confidential settlement agreement related to a sexual harassment case. I think it was, you know, sort of part of Me Too. We don't want women to be silenced, and you know, so the law was unclear at the outset. Did it apply to both sides or just the company, the defendant? Later clarified that it only applies to the company. So, you know, if I was their counsel, I'm trying to segregate the claims that the disclosure, because I'm assuming they're going to want, you tell me, all of these include non-disclosure.
Oh yeah.
Right? Yeah.
Yeah.
So, you know, they're going to want that, but then they would want to allocate a very low sum of money to it because they can't deduct that part of it, right? And
right.
I know the government's obviously going to be aware of that. And I think because this was a new thing, they will likely target it. I have not seen that happen yet, but you know, with any new tax change, it takes a few years. And then obviously, you know, with the new administration and their plans to spend a bunch of money on infrastructure and other priorities and pay for it by increasing the IRS's budget by $50 billion, I suspect that is a stone that will get unturned. So you know, from the plaintiff's side, they will be looking at that allocation, and they'll look at others too, if I had to guess. So that's probably where this would come up, realistically speaking.
No, I'd forgotten about that. It's a great point about the sexual harassment, you know, which is, you know, it's neither here nor there because the law is what the law is. You know, it does provide a weird disincentive, you know, something of a disincentive not to settle those cases, right? You know, because prior to this, you could settle them and, you know, it was a tax write-off for the company and, you know, so they got at least a little something out of it. And now they lose that. I understand the policy concerns behind it. I mean, I think they're legitimate, but it'll be interesting to see, you know, as you say, once IRS starts paying attention to it. Let me ask you, if let's say, you know, your lightning strikes, you get struck by the IRS lightning bolt, they're auditing the company. Let's say they're auditing the company, and this is the company that would only pay it out in 1099. They wouldn't budge. What's the worst that can happen to the plaintiff, right? The IRS says, you know what, we're looking at this. We think, you know, Monday morning quarterbacking, you know, you should have taken a third of this in W-2 and you didn't, company and plaintiff. And let's say the plaintiff, we asked the company, we're like, hey, we've been told some of this needs to be W-2. And the company said, no, forget it. But we took the money because that was a settlement offer. What are the potential consequences, if any, for the plaintiff in that situation?
Yeah, like I said, unlikely to happen, but if it did, they could assess the additional Social Security and Medicare tax against both the company and
Mhm.
the plaintiff and the defendant. And they have 3 years to do so from the tax return original filing deadline or extended deadline, or if you filed late for some reason, 3 years from that date. Here, I guess they're looking at the company. So I'm assuming the company files on time. And so when they look at the company, they could make an adjustment on both sides. There are cases though where they don't. They just make it on the one side and leave the other side alone. I see that. I represent a lot of employers that screw up the payroll tax, and
Mhm.
that's pretty frequent that they just, even though everything was screwed up, they just tag the company for what's owed, and to give the employee credit for Social Security purposes, but they don't actually make them pay it.
Yeah,
The idea being it's not their fault,
right.
they unfair to come after them like years after the fact. So I think it's unlikely to happen. I think that's the likely outcome would be they would just let it go.
Yeah. Yeah. No, I think that makes sense. And I guess then you could show them, right? Like you're like, hey, here are the emails, or we asked them.
We did. I
We
mean, even
tried. Yeah.
yeah, I don't think there would be any like penalties or issues in that case. The question would be, do you owe the taxes?
Yeah.
The other thing to keep in mind with Social Security and Medicare, I mean, obviously I try to minimize all taxes, but with that tax, you actually do get credit towards future Social Security payments. I'm 36, so I'm assuming there won't be any Social Security for me. I'm being facetious. There will, but but
I'm gonna spend as much of it as I can before you get there, Jason. So
I know that's why there won't be any left. No, but so if you we're all likely to get Social Security, so you'll recover like the money you pay in. I mean, it's not like a dollar for dollar recovery, but you're at least getting credit. And I believe it's like your 35 highest earning years or what determine your monthly benefit with Social Security and what age you take it at. So obviously that adds on to the earnings for that year.
yeah, yeah. So it's not a loss.
Yeah.
You're just not getting money in your pocket right now. Let me go back to attorney's fees. So am I correct in saying that for employment cases that it's kind of a above the line deduction? It's a 1-for-1 reduction. If I've got tax liability, I can just take those fees right out of it.
Yeah, it should be completely tax free. You run into issues if it's like hourly because you can only deduct it in the year. So you receive the settlement in year 3, but let's say you paid attorney's fees for year 1, 2, and 3. You now have an issue where the years do not match up to the year of receipt, right?
Hmm.
But in a contingency fee case, it's easy because those two things happen simultaneously. The attorney
Right.
gets paid when the settlement's paid.
Right.
I have not personally been involved with an hourly case like this, but my understanding of what people do is they do like a double transaction with the attorney where you reimburse them and then they pay you back kind of thing.
Yeah.
Everything happens in the same year, and
Yeah.
that like I said, I haven't defended one, but my understanding is that works, or at least
Okay.
everyone believes it would work.
Yeah.
Employment law, it's codified in the tax code that any like federal claims and then any state and local claims related to employment law defined very broadly are includable. It can be deducted above the line. And that's rare. I mean, you used to be able to deduct attorney's fees other ways, but with tax reform, that was removed in 2018. So this is really the only way, unless you're a business or some other limited situations, to deduct attorney's fees. So like when I have non-employment cases, the game is making as much of the settlement non-taxable as possible because you're not going to get those attorney's fees back.
Right.
And I mean, do you care if I talk about that? Because it probably
Go ahead.
Yeah.
Yeah.
So there's a section in the Internal Revenue Code that treats like personal injury awards differently. So if the settlement is on account of personal injury or sickness, it is excludable as income. Like, you don't have to worry about deducting attorney's fees because none of it's income. You only deduct the fees up to the amount of income you earn. So in certain cases, like I've had a few sexual harassment cases that involved two different things. One, just physical activity, literally, the person.
And right.
So that's pretty clear, at least what you can allocate from the pain and suffering side of it to it should be non-taxable. And then less clear if it's like PTSD or some kind of physical injury or sickness that manifests itself due to the harassment. The case law is all over the map. And like the IRS guidance is too. So there's guidance that you like very old, like from the 70s or 80s, that says there must be like an actual like physical touching and it flows from something physical. But then later, the same type of guidance issued probably in the past 15 years on a case involving a priest, like a priest molestation case, where the Internal Revenue Service just acknowledges that it had to involve, even though there's no physical injury to point to. Like, they literally would require you could show a bruise or something of that nature. This involved damages from like 20 years prior, from a long time ago, and there was no evidence, obviously, other than the testimony. And they were like, yeah, of course that involved physical injury, so
right.
And then case law, all over the map. I mean, there's a case where someone has a heart attack, and I believe it was like age discrimination. And then someone's multiple sclerosis was, I'm going to butcher the term, but basically aggravated, so very gray. So I've had those kind of cases where we try to connect as much to physical sickness and the manifestation of that from the conduct.
So what did the IRS in those two cases you just cited, what did they do?
Well, we're
I see.
We got our fingers crossed that we're not going to get audited over the next 2 years or so. But so I was hired to help with the allocation and provide an opinion, basically, so the client could take a position. It was a very large sum of money, so to take a position and not worry. So when you get an opinion, if the IRS audits the person and they lose, there are typically penalties that are associated with that. So they can get out of the penalties by saying they relied upon qualified tax counsel. I've had other cases where we are waiting to get audited, and I look forward to defending them. One is literally like a rape case, and obviously I'm not happy that she was raped. The employer is a very bad person, obviously. They 1099s my client the full like $250,000 she received, and like no one it's a rape. I mean, clearly it's a physical injury, right? And there's it's a government agency too. I asked this government agency to do the right thing and amend the 1099, and they're not. So how that goes, just because a third party issues a 1099 form to you does not mean you have income. I mean, people do erroneous 1099s all the time. But when you don't report it on your tax return, the IRS's computer system
flags it.
They scan all the returns, they flag it, and they send you what's called a CP 2000, and it says, hey, we got this 1099, you didn't report it, we're going to add it to your return. It kicks off a kind of a low-level audit, and so we're just hanging out waiting for that to happen. I did refer them to a CPA who like put it on the tax return and then backed it out, hoping to and I didn't I don't think this is like cheating or anything because it's not income, but to try to prevent the computer system from picking it up, we're
I
trying to
see.
game the
Right.
system. So we'll see.
See if it works. So as long as there's an arguable, like let's say let's look your age discrimination case, right? Like somebody has a heart attack, they say it was because I was discriminated against based on my age. That's a gray area. You're saying like that, one can make the argument that it's tied to work. Maybe you have a medical professional who will testify to that, but it's not a physical touching.
And I think, I don't remember all the details, but I believe like, they were being horrible to the person to try to get them to quit, right?
Yes.
And so the horrible behavior, which only happened because they were old and wanted to leave, but it's more tenuous. It's like a couple steps, right? And, whereas, it's not like someone touched them or, like a more direct causation to what happened. Right. And, if I was the government or the employer, I would argue, well, like maybe there were pre-existing health issues and this person just had a heart attack completely unrelated to what was going on, right? But and that was the government's claim, by the way, they lost. But that clearly is a very facts and circumstances kind of intensive thing. So
and how do the mechanics work on the taxpayer side? You just not, if you're going to take the position, let's say that case, and you're like, you've thought about it, and you're like, we're going to take the position that this was, essentially connected to a workplace injury, and is therefore not income. Do you just not report it? Is that, you're just like, this is?
Yeah, you can go that route. You can go I'm going to try to trick the computer system route. You can go and this would be the best one if the other side will agree to it. They just agree not to 1099 you, that they will allocate it like in this. If you had the age discrimination and heart attack case, you would want the defendant to agree that it's injuries flowing from a physical or a physical manifestation of, and obviously I don't have the specific language.
Sure, of course.
But it's like physical sickness manifestation due to that conduct, right?
Right.
And then they don't issue a 1099, and then you don't report it. You go on your merry way, and you hope and pray you don't get audited, right? And then if you were, they're going to get a copy of the settlement agreement. They're going to learn more information about what happened. They're going to want to, potentially interview the taxpayer, interview the other parties, right? And that's
So what is this? Does the settlement agreement need to say then? Like, this is a physical injury, workplace physical injury, and
like the 1099 rules say if it's like not taxable, you don't have to issue a 1099. Now, will the accounting department or the controller or whoever controls these decisions know or understand that? Maybe not, right? You want to get that worked out before everything is signed. But yeah, you would allocate it as such. And and like I said, most allocations are respected. So that's the other benefit to it.
And then just to, I believe this is the case. So, but if it's a proper 1099 payment, let's get away from the physical injury for a minute. But let's say it's like, we're doing a third. Like you still pay taxes on that 1099, or you just don't pay. You just don't pay employment taxes on that. But you still pay whatever your tax.
You end up paying. So no, because if the attorney's fees. I guess it depends on how you allocate the attorney's fees because they're only a third, right? But let's pretend that those two amounts equal. So the income taxes are offset. There's no FICA tax on the 1099. So you're just paying the income tax and the FICA tax on the lost wages, which is what you would have paid anyways if you had lost wages.
Right.
But
then for the 1099, like let's say we have true 1099 payment. So we paid we're third W-2, right? That comes out, just like no tax problems there. A third, in this case, $10,000 for pain and suffering because it's a discrimination case.
Right.
And then $10,000 for attorney's fees. Now, $10,000 for attorney's fees, top of the line deduction. The W-2 was paid by payroll, regular payroll, so we're fine on that. but you still have to, it's not as if this 1099 portion, this middle is tax-free. It's just not employment tax.
Right, I got you. You report it, and then you have to literally on your tax return
Yes.
deduct the attorney's fees. Yeah,
Yeah.
like you don't like this is probably the point at which TurboTax no longer works for you. You know, and which is very real for me right now because the client I was talking about where we were backing it out, I attempted to do that for them on TurboTax and I could not break the system. So we had to pull in someone else.
Fried its brain.
Yeah. I've been successful before, but I'm not a CPA. So I'm just typing in numbers, doesn't look right. And it didn't.
Yeah.
But yeah, you have to deduct it. And if so, there's two offset dollar for dollar, right? So there's no taxation. But if you forget to deduct the attorney's fees, or let's say you just forget about it, and then a year later you get a letter from the IRS that's like, hey, we got this 1099. The proper response would be, you're correct. I forgot to report this, but hey, guess what? Here's the amount of my attorney's fees that I got to that I also forgot to deduct. Please offset those attorney's fees, and they'll adjust it accordingly. Those are the times when you need someone like me potentially. Unfortunately, that like first letter with the IRS, even when you're accurate, they don't always agree. But yeah, that's what would happen.
Yeah. So we got a question, and this may be outside of your bailiwick since it involves unemployment insurance. Said if one is still collecting unemployment insurance when settlement is concluded and paid, is the plaintiff then required to pay all the UI benefits received?
I mean,
you may not.
I don't know. I mean, the unemployment benefits are taxable. I know that.
Yeah.
But I'm assuming no, but I'm not. I don't deal with the Department of Labor or state departments of labor about unemployment.
Yeah, no, it's a weird area of law, and I would say it varies state by state. So I'd talk to your attorney about that. My initial instinct is no. You would not have to repay that money. It can depend on how it's set forth in the settlement agreement. Generally, if you've got like kind of one lump sum payment, my understanding is that you avoid getting in problems with unemployment insurance, benefits. But I'll talk to your attorney on that one because it does vary by state. All right, while we got you here, this is a little bit off topic, but for let's say clients who have tax problems of their own, let's say you skipped a year paying taxes. What do I do? I skipped a year paying taxes. Do I need to hire you? I think people get understandably in a real panic about this because they think the IRS is going to take their house. They're going to, take their firstborn children, all that. What's the reality of it? What do you do if you've got tax problems?
Yeah, I mean, I think your assessment of the fears I see was accurate. I literally make the same joke that they want to take your firstborn child. But the truth of the matter is, as long as you deal with the problem, it generally doesn't get to that level, and you really do need multiple years, large dollar amounts before those kind of things come into the picture. I mean, technically, is it a crime not to file a tax return? Yes, but it has to be intentional, and the government does not prosecute everyone who commits this crime. I mean,
Sure.
There's way more people out there that have committed that crime than the people they actually prosecute. It's a very low number, but so I don't worry about criminal liability that much. The biggest thing is that I see is that people will put their head in the sand. They nothing happens to them. It's like tax deadline passes and they're waiting for the government agents to break down their door, and it never happens, right? And then they become desensitized to it. Then another year goes by, and another year goes by, and then like year 4 or 5, the government finally shows up, and even at that time, you can still work it out, But it just gets worse. It snowballs. The penalties and interest can be like 50% of the ultimate liability. They charge interest on the penalties and on the unpaid tax. So it's about resolving it. The IRS is pretty friendly for a creditor. I mean, we do bankruptcy too, so we deal with non-tax creditors. The IRS has like way more power than non-tax creditors. Like they don't have to get court approval for most of the things they do, but they use their discretion. Like you really, they want you to voluntarily fix it. That's their goal. Like they do not have the resources to go after everyone, so they want voluntary compliance. So they give lots of opportunities to do so. You know, if it's a large dollar amount, like more than $20,000 at stake, it's worth it to hire someone, in my opinion.
Yeah.
Many times, if you hire a CPA to file the missing tax returns, sometimes they know what they're doing, sometimes they don't. But you know, if it's just, hey, I need a payment plan, they can generally handle it. The question though becomes, like, you know, there are these penalties for not filing and not paying. Can you get out of those? Could you settle the liability? Can you, are there other ways to get discounts, you know? And for all of my clients, like people who hire us, I protect them from all government enforcement action. You know, if something happens on my watch, I view it as malpractice on my part, right?
Yeah.
You know, they hired me to defend them. You know, obviously there are clients that things happen to them, and you know, it's generally they just didn't take my advice, but it's very few and far between. And you know, we sort of stop all of that, and it's really like, what does the client want? You know, do they, what is their goal? Where are they trying to get? And can we get you there or not? If we can't get you there, well, maybe here's another route we can go, or something else we can do. So it's kind of, I could go on about everything we do in very boring detail, but that's kind of big picture of how it works.
Yeah, and I think, and largely as a result of knowing you, just that, you know, it's a negotiation, right? Like, yes, here's, you know, the back taxes that you owe. Yes, we could charge penalties. Yes, we could charge interest, you know, but just like, and perhaps even like you said, even better than other creditors, it's like, okay, what's the art of the possible here, right? Like, and if the taxpayer is operating in good faith, like, hey, I skipped 2 years of paying taxes and I just kind of got behind, but here I am, I'm trying to make this right. You know, it's not as if you're going to have to pay probably the full amount if you come forward, particularly if you have counsel who can work with the IRS and help negotiate this down.
Yeah, if it's your first time having an issue, for sure, you will not pay the full amount. You know, if it's many years and you've been to this rodeo before, I can't make that promise. But it comes down to your financial situation. So that the government will settle with you if they believe you will not be able to pay them in full. You know, so it's a collectability negotiation.
Yeah.
Just to give you an idea of how friendly they are as a creditor, up to $1 million in liability, like 7 figures, they will let you enter into an installment agreement without disclosing your financial information. So you could literally have $2 million in the bank and not have to tell them about it. An installment agreement where they will give you the remaining collection statute of limitation to pay. So what is that? The collection statute of limitation is the time frame they have to collect the money from you when you, from the point in time that you get the first bill, you know, so the tax return is filed and 30, 45, 60 days later, they send you the first notice. The government has 10 years and 30 days to collect from you. That's the collection statute of limitations. So if you have this new $900,000 liability, they're literally going to give you 119 months to pay this thing. Now it's a large monthly payment. And, you know, if I had that person in front of me and I gave them the number, they're probably going to say, "You're crazy, Jason," and we'll go negotiate something better, right? But that's how friendly they are. It's
Yeah.
You know, and it's because they want people to voluntarily enter into agreement. So most of the work we do, like they can get that agreement without us, you know, or their CPA could have. The work we do is, can we get you a better deal? Can we add more value above and beyond that? Or you know, maybe you need time. I mean, sometimes my client's going to pay in full, but their kids have 1 year left in college, and they're like, look, if you can just keep the wolves at bay for a year or two, I'll pay them after that. And I'm very comfortable just delaying and protecting my client and not having them pay for the next year or two. Whereas, other people might not understand how the machine works, how the collection process works. So you get all these like scary letters, where
Yeah.
the IRS says we're going to take your firstborn child.
Right.
And so like which letter is a bluff, which letter is real. And we just basically, client relies upon us and we advise them and take care of everything, and they don't have to worry about this problem anymore. It's off their shoulders. The goal is to remove the stress too. And I think we generally do that until like the next letter arrives, and then we have another
Starts all over again.
yeah, which is fine. I mean, I love making people feel better. I love helping them. So.
Yeah, no, well, it's good to know. Well, Jason, thank you so much for joining us today. Anything else you want to opine on, or I didn't ask you about, you think would be important to talk about?
No, I think we're good. Tom, thanks for having me, and I'm happy to help anytime. And it's good catching up. I haven't seen you in the pandemic, so this is
I know, right? It's good to see your face. Well, let people. How would people? We'll send this information out too, but just for those who are on the video, how will they find you? What's the best way to find you?
Yeah, so the easiest way is to call us or go to our website. So the phone number is 404-233-9800, or my friend's website is www.wiggamgear.com, and I'll spell that because both names are unique. So it's WIGGAM as in Mary, GEER.com. So wiggamgear.com. My email is jwiggam, so first initial last name at wiggamgear.com. And yeah, thanks for having me. We represent clients nationwide with federal tax issues, and hopefully you don't have them, but if you do, we're happy to talk.
Person to talk to. I highly recommend you, Jason, and Will too. Will Gear, who does a lot of your bankruptcy work. So thank you again. Very informative. And yeah, enjoy the rest of your Wednesday afternoon.
Thanks, Tom. Have a good one.
All right, take care.